Okay, I'm really delighted to be here with you all today. Thank you to Dean Alexander for that very generous introduction. I've never been to Villanova before. I grew up in Washington, D.C., and I grew up in the 1980s, and there was definitely a time in my life where I viewed Villanova as the enemy. There was an epic basketball game. The mighty Georgetown Hoyas, my beloved team, went down to Villanova in one of the great upsets of all time. And so the wounds have healed over the last few decades. So what I'm going to do today is not talk about the NFL, tempted though I may be. I will talk a little bit about my beloved boss, Justice Breyer, at the end of my time with you all today. And my comments really are going to be driven by my book that I've written on this topic, which is called The Schoolhouse Gate, Public Education, the Supreme Court, and the Battle for the American Mind. The book offers a panoramic look at students' constitutional rights. I view it as examining the intersection of the Supreme Court on the one hand and public education on the other. And the core claim of the book is that it's difficult, if not impossible, to understand the one institution without thinking about the other. And so the claim is that with respect to the Supreme Court of the United States, that if you want to understand the Supreme Court's capacity for vindicating minority rights.
You're muted. The one in law school, you're muted. Can you unmute yourself? I can't hear you. You're unmuted. Someone muted the camera. Can someone unmute?
I am unmute. I will unmute. Okay, I think that I've unmuted now successfully.
Thank you.
Maybe we can mute the other people and everything. Okay. Okay, thank you for that. That's good. You have to. It's a full service operation here. I need to monitor the computer as well. Okay, so I was saying that the book really is about the examination of the intersection of the Supreme Court and public education, and that if you want to understand the Supreme Court of the United States, that you would do well to look at the education decisions, which offer a window into examining the court's counter-majoritarian capabilities. There's a dominant mode of thought in constitutional law these days that the Supreme Court is a weak institution, that it is merely reflecting larger attitudes in American society. And I found myself repeatedly drawn to this notion that the Supreme Court can successfully vindicate minority rights. I think about cases like Plyler versus Doe, dealing with an unauthorized immigrant's right to access education in 1982. That was not a popular decision. I found some polling data that suggested that most people thought that it should be permissible to exclude unauthorized immigrants. And Tinker is another case dealing with students' free speech rights. I'll speak more about that in a moment, that really offers a good window into viewing the court's counter-majoritarian capabilities. The other part is thinking about the Supreme Court's role in shaping public schools. We don't often think about public schools as being legal institutions, but when you step back and you examine the whole host of constitutional rights that the Supreme Court has articulated, it becomes clear that the Constitution does assume a particular form in the nation's public schools. And so the book offers, again, a panoramic look. I have a chapter on the freedom of speech. I have a chapter on discipline, thinking about due process for suspensions and corporal punishment. I have a chapter on religion, of course, thinking about the Free Exercise Clause and the Establishment Clause. I have a chapter on equal protection, thinking about Brown versus Board of Education and race. I have another chapter on equal protection, thinking about sex-segregated schools and transgender students and access to restrooms. It seems to me that these cases are ones that unusually animate the nation. I should say a little something about the end papers in the book. The very first section is a map of the United States. I'll show this to folks at home so that they can see it. And it identifies particular locations where major Supreme Court battles have happened involving students' constitutional rights. And you'll see one of the dots in question is right here in Philadelphia, Pennsylvania, where the Vorzheimer school case took place, where a student was, a young woman wanted to attend Philadelphia's renowned Central High School and was told that she was ineligible to attend because she was born the wrong sex. And this case made its way to the Supreme Court of the United States. Okay, so what I'm going to do today is to talk about the civil rights movement going to school. I mentioned the various chapters that are in my book, and I'm going to talk about some of the cases that have race at the very center of this topic. And so I'm not going to speak about one particular chapter. Instead, I'm going to speak about three different issues. I'm going to speak, of course, about Brown versus Board of Education. And then I will speak about the First Amendment and students' free speech rights. And then finally, I will speak about due process rights involving suspensions. And then I'll conclude by talking about three issues that I care about particularly and that I regard as being implicated in the ongoing quest for civil rights in our nation, and in particular in our nation's public schools. Okay, so with Brown versus Board of Education, one of the things that I try to do in my book is to put a spotlight on parents and students who have the courage to stand up to their local communities and their local school districts. You know, sometimes we lawyers act as though constitutional rights just are handed down from the Supreme Court of the United States, or maybe even a higher power, and we're insufficiently attentive to the way that they emerge from these clashes, often of individuals with governmental entities. And so in my discussion of Brown, I talk about Mr. Oliver Brown of Topeka, Kansas, heading down the street to try to get his daughter admitted to a public school that was much closer than the one that Linda Brown was attending on the other side of Topeka. There was a school that was around 7 blocks away from Oliver Brown in the Brown family home that was for white students. And instead, his daughter Linda, at a very young age, was required to go clear across town, a journey that required her to go through a railroad switching yard. It was quite dangerous. And Oliver Brown demonstrated, in my view, remarkable courage by walking down the street with his daughter in hand to make a visit to the principal's office. Linda Brown described her father as being particularly, often being subdued, pretty calm person. In this particular day, Linda Brown's left in the waiting room while Oliver Brown goes into the principal's office, and Linda, a 9-year-old at this time, can hear elevated voices, right? There's definitely contestation happening about whether Linda would be permitted to attend this school, and then her father emerges, grabs her by the hand, and walks briskly home. And so I try to pay honor, I try to honor the people who put their necks on the line in a very significant sense. As you all know, Brown invalidates segregation in schools, and it's found at the time in 1954 in 17 different states, and it's permissible in 4 additional states. So 17 states require racial segregation, and 4 additional states permit racial segregation if the localities want them, and Kansas was one of those states. Some people try to minimize the significance of Brown and say all the Warren Court was doing there was bringing the South into line with national attitudes. That seems to me to offer an impoverished understanding as to what Brown was up to. If there are 21 different states that are permitting, at least, if not requiring, racial segregation, it's difficult to understand that decision as simply invalidating outlier legislation that had appeal only in the South. It seems like it was a more widespread phenomenon than that. One of the things I'm trying to do in my chapter on Brown, the 5th chapter of the book, is to offer a revisionist account. This was actually the hardest chapter for me to write. Not only because lots has been written about this, but I've written a fair amount on it as well. Sometimes the more that you know about something, the harder it can be to write. One of the things that I try to do when I'm offering a revisionist account is to question the cult of unanimity that surrounds Brown versus Board of Education. Many of our most venerated constitutional law professors say the fact that Brown was unanimous was a miracle, and the revered Judge J. Harvey Wilkinson of the Fourth Circuit has said one of the things that made Brown so effective was the fact that it was unanimous. And there's something animating this claim, often unstated. The idea would be that had Brown not been unanimous, the South would have resisted with greater force. I'm skeptical of this cult of unanimity. On the conventional account, Chief Justice Warren visited Justice Stanley Reed's office as Brown was being considered. Stanley Reed, we should say, of Kentucky. And he says, Stanley, you're all on your own now. You have to decide whether it's in the interests of the nation for you to issue a dissenting opinion or whether it would be better for us to speak with one voice. And on this account, Chief Justice Warren is using his retail politicking skills as being governor of California to do a great deed for the nation. We pay insufficient attention to the costs of unanimity by saying that this was such a wonderful thing that Earl Warren was able to bring Stanley Reed around. If Justice Reed, as some people suggest, was able to extract Brown 2's mandate of all deliberate speed in exchange for going along with a unanimous opinion, it seems to me that that was a rather steep cost to pay. This is to say, had Justice Reed been able to go it alone, it's possible to envision a more muscular opinion in sort of enforcing Brown versus Board of Education in a significant way. It's also a sort of odd argument when you think about the unanimity because it seems to me that the South resisted Brown versus Board of Education with a great deal of ferocity, even in the absence of a dissenting opinion. How much more ferocious would it have been had there been a single dissenting opinion? The other thing I would say when you think about the cult of unanimity is there are dissenting opinions that are deeply felt involving some contested social issues, and nevertheless, those decisions become the law of the land. You could think about the recent Obergefell decision, a 5-4 decision, and nevertheless, people are able to get married all over the country. Some people believe that Brown did not make a big difference, that it was, no big deal. We shouldn't pay so much attention to Brown. There are some people who say that it's just, we pay too much attention to Brown. I think that's not quite right. I think it was a rather significant opinion, and I have good authority for this proposition. None other than the person that we are honoring today, Reverend King. In 1955, he is the newly elected leader of the Montgomery Improvement Association, the MIA, not, I should say, the Montgomery is an Abomination Association, right? But the Montgomery Improvement Association. He's 26 years old, shockingly young age. You 26-year-olds out there need to think about what you're doing with your lives. And he says, when he's leading the Montgomery bus boycott, he says, if we are wrong, then the Supreme Court of this nation is wrong. If we are wrong, the Constitution of the United States is wrong. If we are wrong, God Almighty is wrong. And the reason that he can offer those statements, of course, is the existence of Brown versus Board of Education. The Supreme Court's imprimatur on racial equality allowed the civil rights movement to lay claim in an effective way to our nation's founding document. It seems to me that that is plenty significant. We also need to do a better job of paying attention to the relationship between the civil rights movement direct action phase and legal dictates that are handed down from the Supreme Court of the United States. Sometimes we view these things as being completely separate, but in fact, they were intimately interwoven. You all who have studied constitutional law know not only about the Brown versus Board of Education decision, but also the Gale versus Browder decision, which formally invalidated racial segregation in the Montgomery transportation system and therefore transportation all around the country. That is a significant decision. This is what Martin Luther King was working toward. And it was a necessary decision because Brown, as you all know, is written as though it's about only education, right? It says when it comes to the sphere of education, separation is inherently unequal. And there's a question about how widely this anti-segregation norm sweeps. And so it becomes necessary for the Gale versus Browder per curiam decision, right? These are not sort of long written decisions by any stretch of the imagination. Indeed, they have been criticized as opinions that do not opine. They do not explain their reasoning for invalidating racial segregation. We're still at our infancy of understanding the civil rights movement, truth be told. We think typically about brave African Americans standing up against oppressive white people, and of course that is a dominant, the dominant view of the civil rights movement, and for good reason. We need to pay a little bit more attention than we currently do to the cleavages that existed within the civil rights movement, broadly defined. These folks were often friends, but sometimes rivals as well. And the mighty Thurgood Marshall is purported to have said, after Gale versus Browder is handed down, the decision invalidating racial segregation in transportation, he's purported to have said, Thurgood Marshall was, all that marching for nothing, right? All that they needed to do was to wait for the legal decree to be handed down. They didn't need to march. Now, that, by my lights, is an impoverished understanding of how constitutional meaning is created, and surely Martin Luther King and his compatriots in the Montgomery Improvement Association were doing important work in shaping constitutional meaning. Okay, the second thing I'll talk about is free speech and the forgotten origins of student speech and constitutional rights. So people who have taken an education law course know the foundational case in this area is Tinker versus Des Moines Independent Community School District. It's a wonderful decision, and it grows out of course, Des Moines, Iowa in 1965, when some students get together and say they want to wear black armbands on their sleeves in protest of the Vietnam War. This is December 1965, at a time when, to the extent that people thought about the Vietnam War at all, they thought that the United States was right to be engaged, long before the rise of mass mobilization against the Vietnam War. And it's an open question at the time as to whether it's permissible to tell students they cannot wear the armbands. When the Des Moines education officials get wind of this, they say, oh no, that is too hot of a topic. And with some force, they say, we have a graduate of Des Moines High School who has died over in Vietnam. And he still has friends who are here. And if you all wear these black armbands, his friends are going to take you as though you are dishonoring his memory and indeed his sacrifice for this nation. So in order to keep the peace, you cannot wear these black armbands. It's an open question as to whether education officials have that authority. Justice Fortis writes a magnificent opinion. It gives me the title for my book. He says, it can hardly be argued that students shed their constitutional rights at the Schoolhouse Gate. And he goes on to say that students exchanging ideas on the topic of the day is not some distraction from the education process, but instead is a vital part of the educational process itself. He says our schools cannot become enclaves of totalitarianism, where the official message is the only one that is permissible. It seems to me that Justice Fortis is animated by a Tocquevillian notion of the clamor that defines American society, where people disagree on the topics of the day. So that case is quite well known. Too little known is the fact that there was a civil rights case out of Mississippi that laid the groundwork for the Tinker decision. There was a case called Burnside out of Philadelphia, Mississippi. The facts there emerged 1 year earlier in 1964, where black students in Philadelphia, Mississippi want to wear what they call freedom buttons. In the gendered language of the time, buttons that said one man, one vote, and SNCC, SNCC, right, the Student Nonviolent Coordinating Committee. Similar story happens in Philadelphia, Mississippi, where the principal gets wind of this and says, oh no, that's too hot of a topic. And in fact, there's no material that is allowed in school that is not of an educational nature. And so, in effect, in order to keep the peace, you're going to be prohibited from wearing these buttons. Students of the civil rights movement know Philadelphia, Mississippi, because that's where 3 civil rights workers were killed. Cheney, Schwerner, and Goodman were killed in Philadelphia, Mississippi in 1964 for engaging in efforts to get people to register to vote. Again, it's an open question at the time as to whether the students have the ability to wear these buttons or whether the principal can, as he wished to do, suspend them from school. This is an all-black school. We are in Mississippi in 1964. This is a black principal who is telling these black students that they cannot wear this. And on some level, there's some undoubted truth to the notion that this is a hot and urgent topic. These civil rights workers were killed and their bodies were discovered not long before the students are wearing these buttons. And so it was a contentious issue in the day. Happily, the Federal Court of Appeals said that the students who were wearing the buttons were not distracting other students. They were not interfering. And of course, we today understand that there's something deeply educational and important about the message that those students were delivering to themselves and also their teachers in that school. So this is a wonderful decision, and too often we engage in a sort of erasure of the civil rights roots of our modern constitutional order. So you can see the connection, and indeed, don't take my word for it, I've heard Mary Beth Tinker herself talk about the way that she was inspired by the civil rights movement and by watching young people in the South speak up for themselves in an effort to improve the nation. And so if it's good enough for Mary Beth Tinker, it's good enough for me. Okay. The last topic that I'll speak about quickly before I turn my attention to the ongoing concerns involves the Goss versus Lopez decision, which is out of Columbus, Ohio in 1975. And there, some students engaged in a protest. They were upset because a school assembly had been canceled that was meant to honor what was then called Black History Week. Forget Black History Month, right? There's Black History Week. And they are upset at Central High School in Columbus. And so they have a demonstration. The demonstration, to hear the principal tell it, got out of hand. And accordingly, the principal suspended somewhere between 75 and 150 students en masse without sort of meeting with the students to see what happened and determine whether they were engaged in this matter or not. And again, it's an open question at the time as to whether students have any due process rights before they are to be suspended. And the Supreme Court of the United States answers in the affirmative. There are very modest due process rights that are afforded students. Basically, it's notice, right? Here's what we believe that you've done. And if you disagree, an opportunity to explain your side of the story. Nevertheless, this is a significant moment in students' constitutional rights. Some people claim that this decision was an abomination because It led to having the ability to cross-examine witnesses, and teachers became shy about dispensing discipline. It seems to me that it's improper to regard Goss versus Lopez as the fault of this. It was, again, very modest procedural protections. But at the time, it really was understood as part of a racial justice movement. The NAACP in Columbus got behind this mission, noted the disproportionate rates at which black students are suspended. And again, this is in the wake of some teeth being given to Brown versus Board of Education and desegregation. And with the extension of due process rights to students, it becomes clear that students are going to have a whole host of constitutional rights. The language that I gave you from Justice Fortis is often clipped in the way that I did, right? It can hardly be argued that students shed their constitutional rights at the Schoolhouse Gate. The formal language actually says it can hardly be argued that students shed their constitutional rights to freedom of expression at the Schoolhouse Gate. And that would mean that maybe Tinker was for free speech alone, and it was unclear at the time as to whether students would enjoy other constitutional protections. So the New York Times and many other commenters understood that in the wake of integration being pursued more aggressively, that this was part of the quest for racial justice. Okay. So now, what are the topics that are ongoing that we need attention to in thinking about civil rights in schools, the modern civil rights movement? The first topic that comes to mind involves suspensions themselves. There are many egregious things about the getting rid of students. Top of my list would be the zero tolerance regime that currently exists. I write a little bit in the book about being suspended from junior high school for making, a bad decision when I was on a school trip involving drinking alcohol on an overnight trip. I thank my lucky stars that this happened in the late 1980s rather than the late 1990s, because I was suspended for 3 days rather than for the remainder of the school year. And with the rise of zero tolerance policies in the 1990s, I would have been thrown out of school for a lot longer than 3 days. And while that adolescent mistake certainly deserved to be punished, it should not have required the entire rest of the school year in my own estimation. And so I hope that there's a growing sense that zero tolerance policies themselves have become intolerable. The next issue that I'll talk about is one that's very important to me. Indeed, if there's any single topic that I care about in the book, more than any other, it is the issue of corporal punishment in our schools. There's a case called Ingram versus Wright. It was decided in 1977, and the facts are truly astonishing. James Ingram is a middle school student in Miami, Florida, and he's on a stage at a school assembly, and he's instructed to get off of the stage. He does so with an insufficient sense of alacrity, and for that pretty classically adolescent form of misbehavior, he is summoned to the principal's office, where he's meant to get 5 licks, in the parlance, with a 2-foot-long wooden paddle. And when James's term emerges, he protests his innocence, and that modest act of resistance brings 2 assistant principals to bend him over the principal's desk. One assistant principal is holding his arms, and the other is holding his legs. And James receives not 5 licks, but 20 licks. And this beating, for lack of a better term, is so savage, so vicious, that James receives medical attention, and a doctor prescribes cold compresses, sleeping pills, pain relievers, laxatives. The pain is so excruciating that 3 days later he returns for more medical attention. At this point, a doctor notes that he has a 6-inch bruise in diameter, a 6-inch bruise that is purple, tender, swollen, and also oozing fluid. This is 3 days after the event. So it's more than 2 weeks before James can return to school, and an additional 3 weeks before he can sit comfortably in school. So the question for the court is, does this violate the Eighth Amendment's prohibition on cruel and unusual punishment? You'd be hard-pressed to think about a more striking case from a lawyer's perspective. James Ingram's beating was part of a larger reign of terror that existed at Charles R. Drew Junior High School in Miami, Florida. Students were beaten for sitting in the wrong chair, for not having the right socks for gym class. And sometimes there were these mass paddlings where they would say, well, you in the front are doing okay, but the people in the back are acting up. And so the whole class is going to get it. In the school district's effort to defend this practice, they ended up making matters worse. There was a principal at Miami Beach High School who testified, and he said, oh no, we don't use corporal punishment in this school. We have a predominantly Jewish student population, and they respond to oral persuasion. Charles R. Drew Junior High School was an entirely black school. And so the evident implication is that the all black students respond only to brute force. So you would think that this would be, you might think this would be an open and shut case. Not so. Justice Lewis Powell writes a 5-4 opinion and says, rejects the claim. He says that the cruel and unusual punishment clause has no meaning in schools. Cruel and unusual punishment must be punishment that flows from a criminal conviction. And because James Ingram hasn't been convicted of anything, he has no constitutional claim to bring here. There was also a due process claim. This Ingram case came up only 2 years after Goss versus Lopez, and you might think that there would be some procedural protections that would attach. That's not how the court saw it. The Justice Powell's opinion, 5-4, rejects that claim. I care about this issue so much because it is not only an artifact of our past. Corporal punishment continues to exist in this great nation of ours. There are something like 18 different states that continue to permit corporal punishment, but that may overstate its prevalence because just 5 states, all located in the Deep South, account for more than 70% of the instances of corporal punishment. And it will come as no surprise to many in this room that black students receive more than their fair share of corporal punishment. So I am an abolitionist when it comes to this issue, and I hope that the Supreme Court of the United States will revisit this matter because I'm hopeful that the current court, even the current court, will, if they were to revisit this issue, invalidate it. After all, there are some people in the current court who are libertarian-minded, and that instance where the state is using a foreign object to strike a young person should make them want to jump up and down and scream. The young people are the last remaining group of people in American society who can be struck by the government with impunity, and that issue must stop. Okay, the last issue that I'll talk about very briefly here is one that was decided when I was a law clerk to Justice Breyer. It was the parents involved in community schools case from 2007. Some of you have no doubt studied this case. It grows out of Louisville and Seattle, where these school districts say, as a result of residential segregation, if we simply assign students to their local schools, we will have racial isolation in our schools. And in order to have schools that reflect the rich racial diversity of our city, we need to periodically take account of race in order to bring people together. And the question is, does this violate the Equal Protection Clause, or what is the meaning of Brown versus Board of Education? There's quite a pitched battle over the mantle of Brown versus Board of Education. Chief Justice Roberts writes for a plurality, and there are 5 votes, to invalidate these plans. Writing for the plurality, Chief Justice Roberts says, in effect, that in the bad old days, schools before Brown versus Board of Education told students where they could go to school based on the color of their skin. These programs, Chief Justice Roberts continues, tell students where they can go to school based on the color of their skin. It matters not one whit for constitutional purposes that these modern programs are designed to bring people together, and that in the old days, in the Jim Crow days, the programs were designed to keep people apart and keep black people subordinated. So Chief Justice Roberts said, this is Brown all over again, in effect. Justice Kennedy wrote an opinion for himself. He did something interesting where he pulled apart two notions that are often conflated. People talk about anti-classification and also colorblindness. And we use those synonymously often, right? An anti-classification, colorblind approach to constitutional interpretation. Justice Kennedy said, I am an anti-classificationist, and because these programs classify individual students according to race, they are impermissible. But he said that school districts are not required to be colorblind in their, say, drawing the boundaries of school districts. And so that does give some wiggle room to school districts who are interested in promoting racial integration. Justice Breyer had many wonderful things. I learned a tremendous amount from him during my year with him. One of the things that he would want me, I suspect, to note is to figure out a way where we could create common ground and think about room that exists for moving the ball forward in a significant way. Surely he would note that nothing prohibits school boards from taking some steps in order to promote the idea of racial integration, even if they cannot classify individual students according to race. Justice Breyer is an optimist, and he tries to think about what can be done. It's very important to bear in mind that the Supreme Court of the United States is often articulating a constitutional floor below which school districts cannot fall. But there are sometimes instances where school districts can go further than the Constitution would require. And so our state legislatures and our city council and our school boards could, if they were truly interested in promoting racial integration, do things. They could pay attention to socioeconomic status and things of that nature. There are some things that are available. We constitutional law people sometimes sort of praise the Supreme Court too aggressively and condemn it too mightily as well. And it seems to me that there was precious little appetite for racial integration as evidenced on the part of school districts before the Parents Involved decision in 2007, and there's precious little appetite for it after Parents Involved. So while I disagree mightily with the Supreme Court's decision in Parents Involved, I don't think that that decision is responsible for the sorry amounts of racial integration that exist in many parts of the nation today. I'm going to end with Justice Breyer. It seems if news reports are correct, it's his day. And here's something that he wrote toward the end of his utterly convincing dissenting opinion in Parents Involved. He wrote in a way that seems to offer an integrationist vision of the Reconstruction Amendments. We often think about what the 14th Amendment prohibits. Maybe we don't pay enough attention to what the 14th Amendment requires. Here's how Justice Breyer ends, and then I look forward, I should say, to your questions and comments and your objections as well. Okay, here's Justice Breyer. What of the hope and promise of Brown? For much of this nation's history, the races remained divided. It was not long ago that people of different races drank from separate fountains, rode on separate buses, and studied in separate schools. In this court's finest hour, Brown versus Board of Education challenged this history and helped to change it. For Brown held out a promise. It was a promise embodied in 3 amendments designed to make citizens of slaves. It was the promise of true racial equality, not as a matter of fine words on paper, but as a matter of everyday life in the nation's cities and schools. The last half century has witnessed great strides toward racial equality, but we have not yet realized the promise of Brown. Thank you very much.
Thanks, Professor Driver. I think we have a couple of minutes for questions. We'll start off with questions in the room, and if folks who are with us virtually have questions, you can feel free to type them into the chat at this time.
So I'm going through Cromwell 2 right now, and we recently spoke about Parents United, actually last week. We were also talking through affirmative action, and the day after we discussed it in class, it was released that they would re-evaluate affirmative action. In limiting schools' abilities to more evenly disperse students of color within classroom, or open them up to other opportunities within school districts and things like that. And the affirmative action question, which I know only applies to upper level education, grad school and stuff like that. Do you see a way forward for us to help more evenly disperse students of colors throughout school districts and ensure that they are not being discriminated against because of these court rulings?
It's a good question, thinking about affirmative action and whether it will remain vital in our modern day. Obviously, the court just granted cert involving Harvard and the University of North Carolina. Said a few times before that affirmative action has repeatedly been administered last rites. You know, people have left affirmative action for dead, and somehow it miraculously survives. Thinking about Bakke, which was written by Justice Powell, he was an improbable savior of affirmative action. He was a chairman of the Richmond School Board at the time of Brown versus Board of Education and was an opponent of Brown versus Board of Education. Nevertheless, he writes an opinion saying that if it's in the name of diversity, this will be permissible. You can view my old boss, Justice O'Connor, as also being an improbable savior of affirmative action in the Grutter case in 2003, and Justice Anthony Kennedy in the Fisher II case also sort of had never voted to uphold affirmative action. And so maybe this line of cases that goes back to 1978 with Bakke should make you think, well, they're not going to extinguish affirmative action. I would not hold my breath on that particular score. And the reason for that, I do believe that many of the current justices are quite distinct from Justice Powell or Justice O'Connor or Justice Kennedy. It's important to remember that they all came from outside of Washington, D.C. They did not have experience working in Republican presidential administrations. And to the extent that Chief Justice Roberts has any project, I think it is about the project of colorblindness. And so it will be very interesting to see how universities respond in the wake of a hypothetical decision invalidating affirmative action. And we can look to the California experience and the Michigan experience. Both of those places had state measures that were designed to get rid of affirmative action. You know, I do think in the K through 12 environment that there is more wiggle room than is commonly appreciated. The Justice Kennedy opinion, at least assuming that it's still good law, does create some place for thinking about, as I said, drawing the district boundaries in a particularly way that would promote racial diversity, or building particular schools and everything. So there are something, taking account of socioeconomic status, which is not perfectly correlated with race, but just as nothing in the Constitution as currently interpreted would prohibit universities from engaging in legacy admissions, nothing would prohibit them from engaging in socioeconomic status diversity. So there are some things that will remain on the table, even if the law is in the midst of changing, which it seems like it is. Others, please.
Yeah, I'm wondering if the Supreme Court revisits the corporal punishment cases, do you think it would be brought again as an Eighth Amendment claim, or do you think that that's the type of claim that could also be considered under a substantive due process?
It's interesting to think about, I would think that the Eighth Amendment would be the more logical home rather than the substantive due process clause, although I could imagine an argument going to sort of, bodily integrity and things of that nature as well. And there certainly is magnificent language from, Meyer versus Nebraska about freedom going beyond bodily restraint. If it were to have appeal to the current court, folks who style themselves sort of, textualists and originalists might be embarrassed by Justice Powell's claim that cruel and unusual punishment must flow from a criminal conviction, because after all, those words don't appear in the Constitution of the United States, and so they might be hesitant to say that was decided exactly correctly. It's also worth emphasizing that the legal landscape has shifted pretty dramatically since the 1970s on this score. At the time of the Ingram case, only 2 states prohibited corporal punishment in schools. Those states were New Jersey and Massachusetts, if memory serves, whereas now the majority of states prohibit corporal punishment. And in some of the death penalty cases, and I bring that up because of the Eighth Amendment context, they do pay attention to where particular states use the sort of contested measure and everything. And so I am quite hopeful that the current court, if it were to issue a decision in this area, would bring some relief. And I do talk in the book about it being possible to have a coalition of liberals and libertarians to find common ground. Again, this is Justice Breyer in my mind, who would say, I know that we've lost, but you need to figure out a way to make arguments that appeal to them rather than sort of, getting angry and, banging your fist on the table. That doesn't do any good, would be Justice Breyer's view. Instead, you lost today, make another argument, a better argument tomorrow. And so I say in here that we need liberals and libertarians to come together in the issues involving the Eighth Amendment. I'm also thinking about criminal procedure, the Fourth Amendment, and suspicionless drug searches that libertarians should not be happy with. And also the freedom of speech. Now, this book was published a couple years back now, but of course there was a major student speech decision out of the great state of Pennsylvania, right? Thinking about the curious case of the vulgar cheerleader, right? Brandy Levy. And some people were skeptical of my claim at the time that it might be possible to pull together a coalition, but as you all know, that was a lopsided decision vindicating students' free speech rights. And so it is important, if you are a liberal like myself, to think about how arguments might be made to appeal to the current court. I understand that there is a lot of despondency around the court in this moment, but from my own perspective, it's important to be creative about making arguments that can, cobble together a majority. I saw another hand.
Right here. Hi. First of all, thank you for being here. So since the 90s, we've seen a proliferation of charter schools and since then school vouchers. And charter schools don't have the same regulations as traditional public schools do. Given Dr. King's vision of equal education and justice, how do vouchers contribute and charter schools contribute to the promise that Reverend King espoused, if it does at all?
Very interesting question. A couple things to say about it. It's an open question as to charter schools and their relationship to constitutional law. The Fourth Circuit is entertaining, has entertained a case about this, that reasonable judges have disagreed about whether charter schools are governed by the Constitution. My own view on that question would be yes, that they are, and I would be skeptical of the ability of a state to get rid of its requirements to conform with constitutional interpretation by just saying, okay, we're just going to have all charter schools and everything. That would be a way of ducking their constitutional responsibilities. But again, other people see that issue differently, right? One of the virtues of charter schools, proponents would say, is that they avoid schools needing to comply with all of the red tape that sort of binds public schools up. yeah, I'm a constitutional law professor, so it will come as no great surprise that I don't view the Constitution of the United States as, bureaucratic red tape and everything, right? This is our founding document. As to the voucher question, this is one that the court has entertained, most prominently in a case called Zellman versus Simmons-Harris in 2002, dealing with out of Cleveland, where some, a few $1,000s was given to families of low means to be able to use these vouchers at private schools, the overwhelming majority of which in Cleveland were religious schools and largely Catholic schools, but not only Catholic schools or not only religious schools, but private schools as a whole. It's an open question as to whether this violated the Establishment Clause, and the Supreme Court in the Zellman versus Simmons-Harris case says this does not violate the Establishment Clause. President George W. Bush very much laid claim to the mantle of Brown versus Board of Education. And if you listen closely, you could think about Dr. King as well, right? Where he says this decision is the Brown versus Board of Education of our time. And indeed, some conservatives are drawn to this idea that, education is the civil rights issue of our time. Dr. King was a protean figure, and people are able to lay claim to particular snippets for their own purposes. So these are absolutely important issues and ones that the court is continuing to confront. There's a case out of Maine before the court right now that it's called Carson that is dealing with a related issue. And so you could see some movement in this issue. Do we have time for another question?
Yeah, I think we have time for one more question. If there's a question in the room or a question from the audience or the chat, all you can.
Please.
I have a question. Considering you're a constitutional law professor, I was thinking about how the varying levels of scrutiny under equal protection in terms of what protected class we're looking at apply in the school context, and whether there is merit to ordering these classifications in terms of protection, race where gender gets less protection and sexual orientation gets even less and financial status gets absolutely nothing. Is there any merit to that system, especially in the public school context, especially in Kennedy's anti-classification view?
It's a very interesting question. The tiers of scrutiny are what sent me to law school in the first instance. As Dean Alexander suggested, after I graduated from college, I got certified to teach public school, and I thought I was going to be a public school teacher. And then I went to England and I studied San Antonio Independent School District versus Rodriguez, which you referenced a moment ago. And that case is all about the tiers of scrutiny and whether this education is a fundamental right or whether class is whether wealth is a suspect classification. And I read this opinion, having not been burdened by a day of law school, and I thought, well, I really need to go to law school if I'm going to, make sense of this, because this seems like they're making it up as they go along. And then I went to law school and I realized that they were making it up as they go along. So I have a fair amount of skepticism of the value of these tiers of scrutiny, and it sounds like you do as well. So we have common ground there. Okay, well, thank you so much. It's been a real honor.